Hello students, welcome to Legacy Academy. In today's video, we are going to discuss about the Karnataka's domicile quota in jobs bill that made a news headline, and the bill however has been deferred and it has been withdrawn. But what the constitution and the courts, whether the high courts and supreme courts of India have to say about such kind of quota in the jobs, whether it is constitutional or unconstitutional, let us try to understand this. So first of all, you to give the brief idea, brief context of this particular news. So recently, in the last week, the Karnataka government approved and then immediately withheld a bill that would have resulted into a mandate where 75% of reservation in the non-management category of job and 50% reservation in the management jobs for the local candidates would have been ensured in the private sector functioning in the state. So before Karnataka, it is not the first time that only state of India which has come up with such kind of idea, such kind of reservation. Other states such as Haryana and Andhra Pradesh have also attempted to provide jobs for the locals, the population, by introducing reservations in the private sector. However, the laws passed in both Haryana and Andhra Pradesh have not been implemented, and the reason of non-implementation obviously being legal and political reasons. So let us try to understand first of all about what the constitution has to say about this matter. Now, when the debate was going on, when India was emerging as a nation after defeating the British colonialism, while framing the constitution, the main architect of the constitution, Dr. Baba Sahib Ambedkar, Dr. B.R. Ambedkar, envisaged a common citizenship throughout the India, irrespective of the local jurisdiction of the provinces and the Indian states. Now, Article 19, which basically deals with the freedom or the fundamental right guaranteed to every citizen, it says that every citizen's fundamental right is to move freely throughout the India, irrespective of the boundaries of the states. And the citizen of India can reside and settle in any part of the country and to practice any profession or to carry on any occupation, trade or businesses. Obviously, there are some safeguards related to scheduled tribes, but this is the general freedom given to the citizens of India. At the same time, the Article 15 also states that there should not be any kind of discrimination by the state against the people or against any citizen on the grounds only related to religion, race, caste, sex, place of birth, or any of them. So these two can be understood as the guiding principle behind whether a job reservation or this reservation quota in the jobs of the locals or for the people or domicile of that particular state should be allowed or not. The discussion that has been held largely in the courts of India revolves around these two articles. These fundamental rights have no geographical boundaries as such. This is something that we can understand from the paraphrasing that we can see here. Now also, if we talk about the other article, that is Article 16, it also guarantees equality of opportunities for the citizens of India in the matters of public employment. Very, very important. We are talking about the public employment. That means we are talking about the government jobs or the jobs in the government sector. Now it prohibits also in public employment any kind of discrimination on grounds only. Now, main thing you have to keep in mind here is grounds only related to religion, race, caste, sex, descent, place of birth, residence, or any of them. So here the interesting things is place of birth and residence. In the case of public employment, the state cannot discriminate against the people. Also, Article 16 state that it allows the state to prescribe a requirement of residence within that state for public employment. That is one kind of safeguard which has been introduced in the Article 16. Now, this is not the same as place of birth, but only a certain length of residence during or before the employment. What it means? It means that any person who is living in a state where he was not born, if he has lived in that particular state for an extended period of time, that has to be determined by the state government itself, then he can be considered as a resident of that particular state, and whatever reservations or benefits the state government want to give to its resident will be applicable to that person as well. So this is what freedom which has been granted to the state government in the Article 16. Now obviously, when the debate was going on in the Constituent Assembly, you know that India before was fractionated into many governments. You have many principalities, many kingdoms are there, and the stellar job that has been done by the first Home Minister of India, Sardar Vallabhbhai Patel, in amalgamating all these states into a territory of India, into a nation of India, is something that we have to understand. But at the same time, they were also understanding and cognizant of the competing sub-nationalisms when it came to affirmative action. And in this case, again, the Baba Sahib Ambedkar, he has opposed the idea of place of residence as a criteria for public jobs. The reason behind this is very simple. He said that we start using the place of residence as a criteria, it will actually dilute or subtract the value that we are trying to promote. What value we are talking about? The value of having a common citizenship. That means the identity of every person in India, every citizen of India should not be associated only to the states, but also to be an entire country or entire nation as well, which we have established by this constitution. However, he was also convinced that just there should be limited application of domicile rules whenever required, because if this idea is implemented strictly, many people will just migrate or move from one state to other state, will take the plums from that particular state, will take the benefit from that particular state. That is the only sole motive which people will migrate to. So we also have to hinder such kind of migration or limit such kind of migration. So though he was not, we can say, he was opposed to the idea of place of residence, but also he wanted to have a limited application of domicile rules wherever it is applicable. Now, in this case, Article 371 of the Constitution provides special concessions to several states, allowing relaxed rule for the recruitment, especially implemented in the northeastern states of India. Now, here one question that we have to understand is public sector versus private sector, because Constitution largely talks about public sector. In this case, the Constitution has no manifest provision which allows states to make laws mandating reservation in the private sector. But as a counter argument, the state governments have argued that they can enter into the private sector as they have provided several kind of concessions to the private sector. These concessions being in the what we can say, in the areas such as tax concessions, where tax breaks have been given to the private enterprises, private companies. Also, cheaper land has been given to develop industries, to develop their this offices and all this kind of thing. Now, since the state government believes that these kind of concessions government have provided, they have full right to enter into private sector domain and make reservation as suitable and fit for that particular sector. Now, if we talk about the recent judgments that have been given by the courts of India across the India in this matter, let us try to understand one by one. Now, one thing that we have to understand, that as far as the domicile rules are concerned, courts ruling on domicile quota have largely involved in the colleges or universities related to admissions, elevated criteria in marking while evaluating for the competitive examination, as well as fee structures, where in some areas the local people have to pay lesser fee as compared to the resident from the other states, but not employment, let alone private employment. So this is something that has discussed in the recent time in the context of fresh development. Now, in this case, if you look at the major case, DP Joshi versus the state of Madhya Bharat, that is in 1955, a fee exemption for the students of Madhya Bharat was given. However, the court paused the rule as it did not go into larger question as to have the existence or admissibility of the concept of regional domicile as distinguished from the Indian domicile. So this was the case related to the difference in the fee structures of the universities. Further, in 1970s, to quell the Telangana movement, the Andhra Pradesh government brought in a law that allowed domicile quota for the jobs in Telangana sector, and this was also deemed as unconstitutional by the Supreme Court of India, as Supreme Court observed that such kind of quotas, domicile quotas, foster a narrow parochial loyalties fostered by the interested parties, and thus it is not in the larger interest of the nation itself. Thus, following that, in the case of Dr. Pradeep Jain versus Union of India in 1984, the Supreme Court observed that we allowed the sons of the soil concept demands to develop, claiming a special treatment on the basis of residences in the concerned state, because recognizing and conceding such demands had a populist appeal. So this was largely done for the political opportunism and as a populist stance. At the same time, Supreme Court also observed that the fostering of the feeling of nationhood is something that is being put at stake here. Further, in 1995, the Supreme Court of India also struck down an Andhra Pradesh law that allowed an extra 5% weightage in marks for candidates whose medium of instruction was Telugu. That means here we can see the special preference was given to the candidate on the basis of the language, and that is something also that has been deemed as unconstitutional by the Supreme Court of India. Now, coming to the recent cases, which is similar to the case of Karnataka, 2019 was the year when again the Andhra Pradesh government passed a law similar to the Karnataka bill that we have seen. In this case, when challenged the court in 2020, the Andhra Pradesh High Court made a prima facie observation that the move might be unconstitutional. That means having such kind of quota in the jobs for the residences in the private sector might be unconstitutional. However, the case is yet to be decided on its merits. So, it will be decided somewhere, it's believed to be in the month of September, October. Another state in the following year, that is Haryana, it passed a law which reserved 75% of the jobs in the private sector with a monthly salary of less than 30,000. Originally, it was 50,000. Later on, it was reduced to 30,000 for residents of Haryana only. Again, the Punjab and Haryana High Court basically came into picture and struck down the laws as unconstitutional. The state's appeal is pending before the Supreme Court again. So, as we can see, similar laws passed by Andhra Pradesh and the Haryana, they have not passed the test of constitutionality in the respective high courts. Now, obviously, the matter is in the Supreme Court, so we have to wait and watch. But still, even if we take this view that in the future, if Karnataka passes such kind of bill and brings such kind of act, whether it will be given a green light by the judiciary, that is still not very clear. So, that is all for this particular video. Thank you very much.